you all very much for coming. I'm excited about being here, so I'm hoping you are too. So this is the joint St Philip's Chambers LexisNexis seminar on the new Part 36. It's a big deal, so I'm hoping we'll learn a lot. I'm the head of the dispute resolution group here at LexisNexis, and we're really, really grateful to St Philip's for inviting us along to co-chair this. This is actually the third of a series of seminars that Ed has been running. There's been one at Leeds, two at Birmingham, and finishing off with this one today, which is, with it being the last one, will be the best of all. I'm just checking to see whether there's any repeat attenders, and I think we're fine. So it doesn't really need to be said, but we're very fortunate to have Ed helping presenting this, because as well as being a Lexis PSL Consulting Editorial Board member, he is of course the chair of the Civil Procedure Rules Committee, who looked at the changes required to Part 36. So he's uniquely placed to give us the inside track. As you'll know, this has been a complex area of law, throwing up a number of cases, such as F&C alternative investments, which on the applicability of the regime to counterclaiming defendants, Evans and Royal Wolverhampton Hospitals withdrawing or adversely varying a Part 36 offer within the relevant period, and Ted Baker. And then there's also my personal favourite, cynical claimant offers, which is A, B and CD and Hook and Robson. Ed will talk us through the changes which have risen as a result of these cases. You'll be aware that the new Part 36 statutory instrument was published just before Christmas, and me and my team have been busy making sure that our materials are up to date, ready for the go-live date of April. On that note, this is where it gets even better news. We've got a gift bag for all of you. You should all find it on your chair. In there, you've got a load of goodies, including the LexisNexis Dispute Resolution Minimag, which Ruth and my team has put together on Part 36. I hope you'll find that in there. There's also an article that Ed has written for the New Law Journal. And I think best of all, there's an annotated guide to Part 36, which Ed has produced. If I were you, I would probably have that to hand throughout the presentation, because it might mean you need to take fewer notes. Before I hand over to Ed, just really brief bit of background, if you'll allow me this, in relation to the Lexis PSL Dispute Resolution module. As I'm sure a lot of you will be aware, it's an online research tool for lawyers, combining practical guidance, precedents, bespoke news analysis, and workflow tools, such as the cost budgeting calculator, something which will be familiar to a lot of you here. Okay, in addition, all of the material in your bag has been loaded onto a memory stick, so if you do want to circulate that around your firms, that will make it easier for you to do. Before I hand over to Ed, a few house rules. There's no scheduled fire alarms for today, so if you do hear an alarm, it's the real thing, and follow me out of the building. Can you please make sure you switch your phone to silent for the duration of the seminar? And also, this seminar is going to be filmed, and we will be releasing clips onto our DR blog. You'll find further details about that in the magazine. Okay, running order for this evening. Main event coming up with Ed, following which there'll be some Q&A. Can you do me a favour with the Q&A, and that is, if you have a question, put your hand up, then you'll stand up and we'll hand you a mic. After that, there'll be some refreshments downstairs. Thank you very much, and thank you to Ed.
Well, many thank yous to LexisNexis for that generous introduction from Neil, and also for co-hosting these series of talks, and also for these materials. Now, I've got young children, and my little 5-year-old, if she were given the party bag at this stage, might not be guaranteed to stay, or at least to focus. So I'd be grateful if you would. And thank you again to LexisNexis for putting all of this material together so well. One small correction I perhaps ought to make, just in case Lord Dyson gets to watch the video of this. I don't chair, of course, the Civil Procedure Rule Committee, but I have chaired the work that we've done on Part 36. And in many ways, it was a real treat to be able to get our sort of hands-on, a major part of the Civil Procedure Rules, and to be able to sort of refashion it. So much of the time of the Civil Procedure Rule Committee is taken up with other jobs. If you're daft enough to have wasted your Christmas reading our Civil Procedure Amendment number 8 rules of 2014, Schedule 1, of course, of which was our shiny new Part 36 that you've got, then you would see, for example, that one of the things we've recently worked on is that should you have a non-molestation injunction against your partner in France, Germany, or wherever else within the EU, you can now register that and use it within the British courts. Other things that we've had in our in-tray in my time on the Rule Committee, which I never thought I'd get involved with as a commercial barrister, the terrorism prevention and investigation measures. There's a rule all about TPIMs. We had to deal with that. And my personal favourite, but if this is your litigation, I'm sorry for taking the mickey, having to deal with the Aarhus Convention on costs in environmental litigation. Again, part of our in-tray. So much of our work is reactive. Other parts of it is very policy-driven. Most obviously, the huge work that we had to do on Jackson. And amongst the person injury lawyers in the room, you will know that I'm afraid the government's teeth remain stuck into you because of the further work they've done on low-value claims through the portals, streamlining those claims procedures, ever driving down the fees that can be recovered for them, and the even more recent work on whiplash claims, which are the latest subject of the government's focus. On top of all of that, but just because we're a bit embarrassed about it, really, we've been working our way through the rules of the Supreme Court and the County Court rules. Remember those? Well, I'm afraid they still appear in your green and white books, as you know, but we finally got habeas corpus into the CPR. That's the new Part 87. So we're up to 87 parts now, and that's the last one of those that we put into proper measure. So on top of all of that agenda, the reactive stuff, the policy-driven stuff, moving things that really ought to have gone into the rules 16 years ago, when the Wolf reforms came into force in April 99. As well as all of that, it's fairly rare for us to get the time to have a major go at a part of the rules, and that's what we've been able to do with Part 36.